So today we have the great honor of welcoming Luke Dimitrios Spieker, who, as you know, is an award-winning author of a book on EU values before the Court of Justice, foundations, potentials, and risks. He's also a postdoc fellow, research fellow at Humboldt University, and could not be better placed to discuss the role of EU values in general, but also particularly of democracy, which is why he's come here to speak.
We don't hear you.
Because we had not pressed. Okay. I just introduced Dimitrios. I hope you all know who he is by now. But he could not be better placed to speak not only of EU values in general, but of democracy in specific. As you well know, EU values has been very much a topic of scholarly attention, but also of litigation before the Court of Justice in what has been themed or called the rule of law backsliding cases with respect to Poland and Hungary. Actually, very recently, Christophe Hillion, Tommaso Pavoni, and others have come up with a different theory of rule of law front-sliding and the restorative disobedience, which I find quite interesting. That raises also important issues and questions about the role of EU institutions and the role that they should actually play in restoring liberal democracy to institutions after periods of democratic erosion. Now, the protection of EU values is certainly of great importance from an internal dimension, but also from an external one, because I would argue that in some cases before the court, such as the case on Venezuela, but also on the Chinese Chamber of Commerce, the court is also now being gradually and perhaps indirectly being asked to reflect on the democratic credentials of foreign states, but also foreign governments, and how this impacts the capacity of them to have standing before the Court of Justice. To unpack the complexity of this all, the internal, the external, but primarily the dimension of EU values, we have here today Luke Dimitrios Spieker. I'm going to repeat that he's the award-winning author of EU Values Before the Court of Justice, Foundations, Potentials, and Risks, because I don't think everyone was hearing online, and I think this is important. And you also have the pleasure of welcoming as discussants Cecilia Riscalaire, who you know well. He's your professor of EU and human rights law here at UCLouvain Saint-Louis Bruxelles, and also the author of an upcoming monograph, certainly awarded, on the EU and human rights, understanding a single regional player, and online, and I hope that you can see his face very soon after Dimitri's talk. We also have the pleasure of welcoming Dr. Yann Lorans, who is a Reconstitutional Research Fellow, now a visiting researcher at Nova School of Law, my alma mater, and who works exactly on the role of the EU in defending democracy through media regulation. So without further ado, Dimitrios, I will give you the floor for about 40 minutes, and to each discussant about 10 minutes after to provide their comments, and then we will open the floor to the audience on site, but also online.
Yeah, amazing. Thank you so much. Thank you, Cecilia. Thank you, Teresa, for this opportunity to present research that I'm working on, I think now for almost a decade. I started as a student, just like you, writing a seminar paper, continued then as a PhD on that topic, and now I'm a postdoc, and you see, still talking about this topic. So I guess you can see that you can make quite a living with a seminar paper. So you should bear that in mind with your next one. You invited me to talk about activating Article 2 in the Union's value crisis, with a special focus on the Court of Justice of the European Union. And before coming to the program that we're going through in the next 40 minutes, I usually like to start with the problem. And that is a problem that I guess you already had this morning with Cecilia. And that is the... Oh.
Is it on?
Right.
No, I thought it was.
Yeah. That is... Maybe.
Great EU lawyers, very poor.
Technology, that's...
Otherwise I can do it. You can just...
No, but it worked. Wait a second.
Ça marchait très bien.
Okay. Amazing, good. So back to the choreography. No, that's a problem that you addressed probably this morning with Cecilia in her class, and that is the illiberal turn in several member states. I know that we have some political scientists also in the room, So I'm referring here to an index that you might criticize for being maybe too objective in that sense. The Planck Institute Democracy Report of 2023 actually shows you very visibly or very, let's say, illustratively how this decline in some member states, especially Poland and Hungary, in terms of democracy, the rule of law and fundamental rights, has unfolded. And the bigger idea behind all that decline was this here, the concept of a liberal democracy, coined especially by Viktor Orban, the Prime Minister of Hungary. So what is this concept of illiberal democracy all about? It goes against one very central insight that we know in constitutional law and political theory since the founding days of the United States, I would say, in the Federalist Papers. And here I just have a quote by James Madison, who said that the structure of the government must furnish the proper checks and balances between the different departments. So a central idea, a central insight of constitutional democracy or liberal democracy is that there must be checks on power, checks and balances. There is not just a purely majoritarian will of the people, but there's always, this majoritarian will is always reined in by these checks. And these checks are not only independent courts, it is also the political opposition, it is the voters, it is free academia, free media, or civil society organization, NGOs. So you can imagine that probably the first, let's say, target in the autocrat's playbook is always attacking these checks and balances. This system can also, or is mirrored at the EU level itself. If we look at Article 2 TEU, a provision that you also touched upon this morning in Cecilia's class, you can see that the Union is founded on the values of respect for human dignity, freedom, democracy, but also equality, the rule of law, and respect for human rights. And I very much like the conceptualization by Advocate General Tamara Chapeta in this upcoming case, Commission v. Hungary, where she says that the vision of what a good society is in the EU constitution is expressed exactly in that Article 2. These values, read together, paint a picture of a constitutional democracy that respects human rights. So the idea of liberal or constitutional democracy is deeply enshrined in the EU treaties. However, it has been under attack in several member states. And as I said before, checks and balances are usually the first target in the autocrat's playbook. And there we can see I think very strongly in what happened in Poland. Since 2015, the former peace government, especially here under Prime Minister Morawiecki and the party leader Kaczynski, started a full frontal attack against the Polish judiciary, targeting first the Constitutional Tribunal, nominating 3 judges who were...
You're not in the camera.
Oh no, I'm not in the camera. Sit down.
If you prefer to.
Yes,
if you want, because there are many people online and they're
yes, of course, yes. Okay, I'm sorry. Then I need this. I'm sorry. Okay, good. We are still testing. Oh no, I can.
No.
Okay, I hope now you can see me. So, yeah. So the first target was obviously independent courts. And when I say independent courts, I mean first and foremost the Constitutional Tribunal of the Republic of Poland. And what did they do? They nominated 3 judges who were already nominated by the previous government, but kind of replaced them with candidates they liked. And then slowly kind of put the entire Constitutional Tribunal under their control. But the Constitutional Tribunal wasn't the only court that they overhauled. What they did was then also target ordinary courts, such as, for instance, the Polish Supreme Court. And you can really see a very elaborate scheme here. They lowered the pension retirement ages, sent a lot of judges into retirement, hijacked the nomination procedures, so filled the new spots with people they liked, and the rest of the judges they couched with disciplinary proceedings by installing a completely new disciplinary chamber at the Polish Supreme Court. So that was quite an elaborate attack. The big question is, what can the European Union do, or should it do something? So the first question is, why should the European Union actually intervene? Why is external support necessary? Well, external support is necessary in such a situation because exactly the internal checks and balances are no longer functioning, right? So we have a text on a constitutional tribunal which should normally correct the government or kind of put shackles on it, but it doesn't work anymore. So we are dependent on external help, which is then the European Union. The question is then, why is it the European Union and not, for instance, the Council of Europe that should intervene? Well, the EU depends to a large extent on member state institutions. Member state governments sit in the Council. European law is enforced by national courts in national proceedings. So we have an intertwinement, an enmeshment of institutions. So a problem in the rule of law or democracy or fundamental rights in one member state is not a problem of that member state. It's a problem for the entire European Union. So there's a strong interest at the EU level as well to actually intervene and help. The question then is, if we come from the why to the who should do it? Which institution? First of all, I'm not sure whether you covered this already, but I will guide you through this again. There is this Article 70, which states that the European Council, acting by unanimity, may determine a breach of Article 2 values. Well, I guess you all can imagine that reaching anonymity is very, very, very difficult, practically impossible, and both procedures launched against Poland and Hungary are deadlocked in the Council, and the European Council since they were brought in 2018. So all eyes were then on the Court of Justice. That then leads us to the third question. How? How should we address violations of EU values before the Court of Justice? Again, we have certain provisions, such as, for instance, Article 47 of the Charter, which enshrines a right to an independent tribunal established by law. But the problem is, and you had that, Cecilia told me already today in class, is that the Charter is limited by Article 51. It applies to the member states only when they implement EU law. And let's say the structure of the judiciary was not something considered to fall within the scope of EU law. There was no EU law covering this directly, right? So we could say this falls outside. Then there was a second... Yes. Sorry. And then there's a second provision, Article 19, paragraph 1, subparagraph 2 TEU, which states that member states shall provide remedies sufficient to ensure effective legal protection, but again, also only in the fields covered by union law. Nobody knew exactly what this means, but we will come to that later. And then there was Article 2, of course, right? The prevailing view, however, in the political institutions was this, articulated here by Viviane Reding, the Commissioner for Justice in 2013. And she said, here the quote, well, her way ahead was, okay, we need to actually change the treaties because we have nothing to address what's happening on the ground. We need to change Article 7 from anonymity to something else. We need to abolish Article 51 of the Charter, and we need a new procedure that actually brings Article 2, protects Article 2. So the idea was, under the current treaty framework, our hands are tied. But there was one institution that intervened nonetheless and developed the legal framework that we found in the treaties into something that actually can be used against these developments at the national level. And that is the Court of Justice of the European Union. And with that short prelude, I would now lead you a little bit through the program, what we are going to do in the next 30 minutes. And that is, in the first section, in the first set, I will guide you through the way in which the Court of Justice has operationalized this provision, Article 2. And it will touch upon three different questions. Can EU values be invoked in courts? How can they be invoked? And when, so in which kind of situations can be invoked? So we will touch upon these three questions. And then I will close with an outlook and show how EU values can actually work very differently, or how they should work, in my view, before the Court of Justice in times of regression, but also after the election in times of democratic transition. And we'll come to that later. Okay, so let's then, in medias res, start immediately with the first question. Can EU values be invoked in courts? If you look at this provision here, Article 2. There are generally two big problems that are raised in legal doctrine. The first one is the normativity of that provision. Does it contain only moral values, or is it actually legal obligations? Because you see, Article 2 speaks of values. And the second question is its justiciability, because the standards in that provision are very vague. What does democracy mean? What does the rule of law mean? What is equality, right? Is that really an enforceable legal yardstick? I will treat these questions now one after the other, starting with the normativity. Okay. I will start with the normativity. Drawing here as a good German on a famous German political philosopher and sociologist, Jürgen Habermas, there is generally this distinction between values and principles. The one belongs to the realm of morality or philosophy or whatever. The other belongs to the realm of the law. So values define what is good or bad. Principles define what is lawful or unlawful. So just keeping that in mind, we could say that, well, okay, Article 2 speaks of values, and values are in the field of morality, so case closed, right? Article 2 is not a legally enforceable provision. It is something like a preamble. Okay? However, I believe that that is actually not the case, and let me explain to you why. Again, as a good German legal academic and doctrinal lawyer, I will now take a deep dive into the analysis of Article 2, working on wording, system, history, and teleology, right? The four methods that we use in German legal academia. And all these arguments actually point against understanding Article 2 as a provision that contains moral values. So let's start with the wording. The notions in legal theory, as I just pointed them out, are actually not that clear. If we look at the relationship of values and principles, it is actually not a categorical relationship, but you could argue that they are in a gradual relationship. What do I mean by that? Let's take an example. A value is, first of all, something very abstract, right? It is, for instance, just as here as an example, equality. If you add to that value a prescriptive dimension, meaning a command, a prohibition, or a right, you turn that value into a principle. That you can see here, for instance, Article 21 of the Charter. You have the very abstract value in Article 2, equality, and the more concrete principle in Article 21. Any discrimination based on something shall be prohibited. If you then add a conditional dimension, if you do something, then something happens, then you have a rule. In the event of a violation of the prohibition of discrimination, an employer shall compensate the damage arising therefrom. This is from Article 15, paragraph 15 of the German General Act on Equal Treatment, which implements that principle in Germany. Right? My point now is, along this line, there is no clear-cut border where you can draw a line. Okay, normativity, legal normativity starts here, and something else starts there. It's a gradual relationship. Right? Okay. Then, if we look at the wording, because that's the central point, right? The wording in EU law is never a reliable starting point. Why? Because obviously we have a multilingual drafting point. And if we now look into how these notions of values and principles are used in national constitutional courts, we see that they all use them interchangeably, namely as synonyms. Look at the Corte Costituzionale, speaking of valori e principi costituzionali. Look at the Tribunal Constitucional of Spain, valores y principios constitucionales. Look at the Bundesverfassungsgericht, where human dignity is tragendes Konstitutionsprinzip und oberster Verfassungswert. So you see, they all treat them as synonyms. So why exactly should this be any different here in Article 2? So I would say the wording itself, just speaking of values, is probably no good argument at all. Then now, look at the system. there are indeed several provisions in the EU treaties that attach legal consequences to a breach of values. Article 7, right? It speaks of a breach of it, and it even leads to the consequence of suspending certain member state rights. Or take Article 49 of the TEU. Compliance with EU values is a condition, a legal condition for membership. So to say that article doesn't contain any legal standards is difficult to square with these provisions, right? Which are legal procedures after all. And now I think the strongest argument, and that is the history. If we look at the travaux préparatoires of the European Convention in from 2001 to 2004 that actually drafted Article 2, what we see here is a quote from Valéry Giscard d'Estaing, who was the president of that convention. And he said very, very clearly, on ne peut mettre dans cet article 2 que de valeurs qui sont définies juridiquement de façon suffisamment solide. On ne peut donc pas mettre des valeurs indicatives ou respectables, mais des caractères plus émotifs que juridiques. So he was speaking of legal values, even though that doesn't square with philosophy, political philosophy of Jürgen Habermas, right? But that was the idea. The idea was des valeurs qui sont définies juridiquement de façon suffisamment solide. I think all that speaks in favor of actually actually conferring to Article 2 a certain legal normativity. The big question, so to actually understand them as principles, and this is also how the Court of Justice of the European Union understood them, saying that Article 2 is not merely a statement of policy guidelines or intentions, but that it contains values, which are given more specific expression, concrete expression and principles which are legally binding for the member states. And we will come to that in a second. So that Article 2 is of legal normativity, I think that is clear, established. The big question now, is it actually justiciable? Does it contain justiciable legal standards? And the problem here is, as I already said, that these standards are very indeterminate: democracy, the rule of law, and fundamental rights. So the big question was, how can the Court of Justice render them more concrete, more specific, to actually apply them to a specific case at hand? And here the leading case is the Portuguese judges case from 2018. All this happened actually in the idea, or in the greater context of the Polish overhaul of the judiciary that I spoke of in the beginning. And the Court of Justice used a test case concerning the remuneration of Portuguese judges to actually develop some principles that were then directly applicable to the situation in Poland. So the big question in the Portuguese judges case was that whether a salary cut of judges touches upon their judicial independence. And to actually answer that question, the Court of Justice needed to say, are there actually any EU standards of judicial independence, and where do we derive them from? Well, what the Court of Justice did was combine Article 2 with a more concrete, specific provision of the treaties, one that I already mentioned. It referred to the value of the rule of law in Article 2, and then on the more specific treaty provision in Article 19, paragraph 1, subparagraph 2, where it says that member states shall provide remedies sufficient to ensure effective legal protection in the fields covered by union law. So you see, both provisions were still, let's say, limited. The Article 2 is unlimited in scope. It applies to the member states. It doesn't contain any limitation itself, but it is too indeterminate. Article 19, on the other hand, is limited in scope, namely to the fields covered by union law, but it is very concrete. So it is only in their combination that the Court of Justice actually could develop a standard that applies to the member states in their totality. So it combined a broad reading of Article 19 in the light of Article 2 with a concretization of Article 2 through Article 19. So it's an interplay. I call this a mutual amplification of both provisions. So it said basically that this, in the fields covered by EU law that Article 19 mentions, means de facto that any court that may rule on questions concerning the application or interpretation of EU law, so hypothetically may rule, falls into that provision, must be independent. And how did it reach this conclusion? Well, it said so because Article 19 gives concrete expression to the value of the rule of law, which is unlimited in scope. So this idea of mutual amplification kind of was a breakthrough, I would say. Okay, and the Commission quickly jumped on that bandwagon and brought on that basis 5 infringement procedures against Poland. I will not go into this in detail, we can discuss that later on. But in all these cases, the Court of Justice found a violation. Okay, so to close this, I always like to refer to this quote by Koen Leenaerts, the president of the Court of Justice, who kind of describes the process of concretizing Article 2 values with electricity. And I think I can just read it to you because I like it so much and it's so visual. So he says that concretizing Article 2 may be compared to the way in which the supply of electricity operates. First, electricity is produced and transported at a high voltage. That high voltage then is compared to the values in Article 2. Second, there are a whole range of transformers. Those are the principles, like in Article 19, judicial independence. And last but not least, there is the supply of electricity at the voltage required for electrical appliances in a factory or in a household. Those are the rules. Okay, so you can always kind of think of this process of concretization in that way. And this is not limited to judicial independence. The Court of Justice has subsequently expanded this idea of combining provisions, right? It says, for instance, in Hungary v. Parliament and Council, a case on the rule of law conditionality regulations, that the value of human rights mentioned in Article 2 is then defined through certain charter rights, concretized. Or it's said in the case of Junqueras Fist concerning a Catalanian opposition politician that the value of democracy mentioned in Article 2 is given concrete form through Article 10, a provision that we will look at more closely in a bit. Okay, so you see this is all established, I would say, today, right? You combine a value with a more specific provision. So the combined application of Article 2 is established practice. The big question now is whether there can also be a freestanding application of Article 2 without any concretizing provision. And this is the case Commission v. Hungary, which has already the name Valeurs de l'Union. What we have here is, or what the facts of the case were, is the anti-LGBTIQ propaganda law in Hungary. So what did that law do? It prohibits or limits access to content that portrays, and I quote, divergence from self-identity corresponding to the sex at birth, sex change or homosexuality for minors. Meaning you cannot watch or you cannot see any queer character between 5 o'clock in the morning and 10 o'clock at night. So it's treated a bit like porn. You cannot buy books featuring homosexual relationships, such as Heartstopper, some of you might know this, in a bookshop 200 meters from schools or churches, which is in Budapest, let me tell you, practically every bookshop. And if they're only wrapped in foil in a certain specific section, and bookshop keepers were actually fined, right? So just examples. A deeply discriminating law against, so we would all say, well, value of equality, question mark? Well, the Commission took this case to the Court of Justice and built this on a cascade. How does that cascade look like? Well, it starts with certain directives, like the Audiovisual Media Directive. I said, right, so Netflix, you cannot watch anything on Netflix between 5 o'clock in the morning and 10 o'clock at night. That's the Audiovisual Media Directive. The freedom to provide services and so on. And these provisions then trigger the Charter's scope, Article 51. And in this case, human dignity, Article 1. Your personality rights, Article 7, your freedom of expression, or the non-discrimination principle, Article 21 of the Charter. And then the Commission said something very important. It said that by adopting the legislation cited here in this paragraph, before in its application, Hungary has infringed Article 2 TEU. So this is the first, let's say, self-standing use, even though used in the context of other provisions of Article 2. And the Court of Justice will rule on that, well, we hope in April. We don't know. Okay, so this is where I would say the justiciability question ends, because we simply don't know what's happening. The question now is, we know that Article 2 can be invoked. But when exactly can it be invoked in front of the Court of Justice? And here I would treat very briefly two questions. What kind of breaches can be addressed? And here I will be very brief because, again, we don't know yet, right? This is all very much in flux. I'm simply a bit quoting here what the Commission, for instance, said in the hearing, Commission v. Hungary. And they said that it must be a frontal and deep attack against European society. Not every breach of Article 2 values, not every breach of equality is enough to trigger the bazooka of Article 2. No, it must be a serious and systematic breach, a systemic breach. And there are then some further, let's say, attributes or adjectives that kind of try to make this more specific, this test. They talk about intensity. Is the essence of a charter right affected? They talk about breadth. Is there interference with the multiple aspects of a certain human right? They talk about scope, the number of breaches. Does it occur in a widespread manner? That also then leads to the systemic one. Does it transcend individual breaches? Do we have a widespread and coordinated policy? This is all indicative, right? We still don't know. So we'll see how the Court of Justice will decide on this. Much more important, however, is the question in what kind of situations we can apply Article 2. And this is the last, I promise, the last really legal thing that you need to know about Article 2. And then we talk about a little bit more political, we close with a little bit more political issues. So, we can distinguish generally between three kinds of situations or three kinds of scenarios. Article 2 can be invoked within the scope of other EU law. So we have other EU law that covers a certain issue. That is a little bit what is in Commission v. Hungary at stake, right? We have the Audiovisual Media Directive, the Freedom to Provide Services, the Charter. So Article 2 is not alone, it is deeply within the scope of EU law. A second scenario is that Article 2 violations might be raised beyond the scope of EU competences in areas where the EU has no competence to legislate. And the third scenario is Article 2 violations beyond the scope of any other EU law or competence. So the first one is relatively clear-cut. I would say, yes, that's not a big problem. The only question here is what is the added value then of invoking Article 2 besides other provisions, right? We already established that a member state violates EU law. Why then raise Article 2? Well, I would say there are three reasons. The first is, this is a signifier. It emphasizes the gravity of the situation. Second, it can lead to higher fines, because the violation of important provisions leads to higher fines. The Commission has actually a guideline that allocates to each provision of the treaty a certain coefficient, right? And a violation of this provision has the highest coefficient, right? And then the impact on political procedures. Some of you might already know there is something called the rule of law conditionality regulation. If the Court of Justice establishes a breach of values in Article 2, this can be used immediately in the political institutions to trigger these other mechanisms, okay? To increase the pressure. The question is now, can Article 2 violations be invoked beyond the scope of EU competences? For instance, in fields where only the member states are competent to legislate. Here we must distinguish one very important thing, and that might already be too legal, but we can discuss that later on. Competences and obligations under the treaties are simply two separate things. Don't mingle them ever. Competences define the power of a certain institution to adopt a certain act. An obligation means that a public institution is bound to respect certain things. This is two separate categories. And the Court of Justice has said already since the 60s that even when member states exercise their exclusive competences, they must comply with their obligations under EU law. And that applies to issues of nationality law, extradition, direct taxation, surnames, social security, civil status, the judiciary, whatever you want, right? So in all these areas, the Union cannot legislate, but the member states must still comply with their obligations under EU law. So saying this is an area of national competences is no argument to shield that area from any EU intervention. Okay, the last category, applying Article 2 beyond the scope of any other EU law, is then the one that we have not tested so far, right? And here I can just refer you to what Tamara Chapeta said, for instance. She said, well, Article 2 does not feature any limitation like Article 51 of the Charter. It has no limitation like Article 19 TEU, which applies only in the fields covered by union law. So where should any limitation come from? If we say Article 2 is justiciable, then it must also be justiciable beyond the scope of any other EU law. Well, the President of the Court of Justice disagrees in the hearing, saying, well, probably the limit applies only to the enforcement of Article 2. So within the scope of other EU law, we can use it, we can enforce it through infringement proceedings, but beyond the scope of EU law, there is only Article 70 EU. I don't know where this distinction should come from. To me, it makes no sense, but we can discuss it. Because it says nowhere in the treaties that this is the case. Okay, so we now know Article 2 can become a justiciable legal provision. It can. And we will see how the Court of Justice will decide this in Commission v. Hungary. So, now let me close with an outlook. And this is how to apply EU values, or what role these EU values can actually play in times of regression and transition. And here I think it is very useful to compare the case of Hungary and Poland. What we saw in Poland, for instance, is a U-turn. In 2022, there were elections, and the peace government lost them. And a new government under Donald Tusk came in place, trying to rebuild, first of all, kind of repair the issues of judicial independence. So Poland today is among the top 10 U-turn democratizers. That's how they call it at VDEM. Hungary still continues. So I think we need to. That actually explains what we have these two parallel situations of transition and regression, and we need to think how EU values apply in these, or should be invoked in these provisions. And I suggest this distinction. In times of regression, before election day, the lead value should be democracy. We should aim at safeguarding conditions for democratic change. And why is that? When we learn something from Poland, from the experience in Poland, then it is that the decision to return to constitutional democracy must come from within a certain society, from within the affected society. It cannot be externally imposed. So what the EU institutions can only do is they can ralentir the process. They cannot stop it, but they can make it slower. And they can keep the channels for democratic change open. And that means free and fair elections, right? After a transition has taken, or after we have a new leadership in place, the lead value then shifts from democracy, I would suggest, to the rule of law. And its aim then is to constrain and support a democratic transition. And this then is what we see in Poland. And if I have time, I still have time? Good. So let me briefly start with the first one. So protecting democracy in times of times of regression. What do I mean by that? What kind of threats are we looking at when we look at Hungary? And I already talked about checks and balances, right? So we have certain direct threats, like, for instance, bias in campaign and party financing rules, gerrymandering. That means how you scope electoral districts so that you achieve a certain result. Unfair postal voting, disenfranchising voters who are abroad, who are usually more liberal, because obviously, who is mobile? And then there are more indirect threats to democratic elections, such as, for instance, free media. Fidesz in Hungary has de facto control over 80% of the country's media. Think of that. 80%. And the authorities banned the last independent radio station, Club Radio, from airing. Civil society. There is this Lex NGO, for instance, in Hungary, or it was the Lex NGO, declaring basically NGOs to foreign agents that they had to wear a stigmatizing label saying this NGO is funded from abroad, like an agent. We have free academia. Most of you will be familiar with the story of the Central European University that even had to relocate and now is in Vienna. And now we have the newest addition to this autocratic playbook, which is the Sovereignty Bill, which investigates foreign funding of political parties, media outlets, and civil society organizations, which are accused of operating, I quote, under the influence of Brussels. All this together leads to a situation that the OSCE, the ODIHR election observation, describes as marked by the absence of a level playing field. So today there are no free and fair elections in Hungary anymore, I would say, against this background. And the Commission already started to address certain issues here, right? Like so the freedom of NGOs or free academia, and brought them to the Court of Justice. But that was always isolated, and they never invoked EU values. So the question is, can we do something in the bigger picture? And the bigger picture looks a bit like this. European and municipal elections are actually regulated by EU law. Obviously, European elections, right? There are many provisions containing an obligation to guarantee free and fair elections to the European Parliament. But the same applies also to municipal elections, right? If you are a union citizen, you have the right to actually, if you go abroad, to participate in these. So they also come within the scope of EU law. The big question, though, is this. Do we have more general standards for national elections? That's the big question. And could we invoke Article 2 here? I would say that, let's say, indirect threats, such as independent media and free civil society organizations, can be addressed already by certain acts. And I won't go into detail here, it's too complex, but Johan knows more about this, right? It's, for instance, the European Media Freedom Act and so on. My interest is more broader, and I already talked about Article 10. And this is the last bigger provision that I will discuss with you before wrapping up. Article 10 TEU says that the functioning of the European Union shall be founded on representative democracy, and that citizens are directly represented at the Union level in the European Parliament, and importantly, member states are represented in the Council through their governments, which must, however, be accountable to their national parliaments or to their citizens. So the question is, can we derive from this certain minimum standards for the member states in terms of democracy? Are there any obligations in it? Well, you could say no. It speaks of the functioning of the Union, right? Where are the member states? I have two arguments. The first one is that we say that democracy at the EU level cannot function without democracy at the national one. If we look at the space, the public space in which European elections take place, if that public space is not characterized by free media, free civil society organizations, campaign financing rules and so on, even if it only affects legally national elections, how should that be separated from the European ones? They both take place in the same public sphere. I think it's enmeshed. Just like the judges a little bit, the idea. The second argument is, and I point here to the member state government sitting at the council, well, the provision says that they must be democratically accountable. What does democratic accountability mean? You are elected in free and fair elections. So there should be certain minimum requirements because they are inbuilt into the structure of the European Union. And again, I give you the quote from Junqueras Fies mentioned before. Article 10 gives concrete form to the value of democracy. So we could use Article 2 and 10 to develop certain minimum standards for the member states. And I think I'm already over time, right? We can... I could wrap up, exactly. Then let me wrap up by just saying... No, wait a second.
Yeah.
We're enjoying it.
It's very interesting, so please.
Okay, well, this is really the last point. If we now switch, through Article 10 and 2, we could say that we kind of try to establish EU requirements to keep the channels for democratic change in a certain member state society open, right? As long as it takes until they change course and come back to the path of constitutional democracy. The question now comes, what happens in times of transition? And here I said we should shift our focus from democracy as a lead value to the rule of law. And one very central aspect of the rule of law is, and I here give you some definitions by the Venice Commission or by the European institutions, is the principle of legality, mentioned even as a first one. And what does legality mean? Legality means that you abide the law. So Article 2, containing the rule of law as a value and the principle of legality, actually requires member states to respect their own national law. And the consequence is that any transition needs to be pursued in legal ways. You cannot break the law, even if you want to make things right. So the problem now is that the Polish government finds itself in a very, very bad situation. They have a majority in parliament, but they are not aligned with the president, Nawrocki, who is supported by PiS, and the Constitutional Tribunal is also still controlled by PiS. And that is a problem, because the president must sign every law adopted by parliament. And if he doesn't, the Sejm can, or the parliament, the Polish parliament, can only reaffirm that bill by a 3/5 majority, which they don't have. And even if they would achieve to get the signature or kind of surpass that, there is still the Constitutional Tribunal, which is packed with PiS supporters, and they actually have already annulled or declared unconstitutional several laws that they passed. So the big question is, are our hands tied again, right? Does EU law or the principle of legality leave us in a tight spot? Well, we don't have constitutional options. We cannot amend the constitution to kind of change the composition of the Constitutional Tribunal. We have no legislative options because we have no approval by the president. So the only question is, do we have to wait it out? And this is where, again, EU law can come in, the other facets of the rule of law, and that is primacy and judicial independence I mentioned before, right? And they can help us to overcome actually this blockade by the Constitutional Tribunal through two things, two problems, and this is the last slide, I promise. The one is, if we look at the composition of the tribunal, I already said, right, who sits there, they do not guarantee judicial independence. Today, it is very clear that the Polish Constitutional Tribunal, and the European Court of Human Rights already said so, is no independent tribunal established by law. If that is the case, its decisions, and that is what the Court of Justice said, are no longer binding. National courts can deviate from them. And the Court of Justice very recently in December re-emphasized that, saying the Polish Constitutional Tribunal is no tribunal established by law. So its decisions do not have to be followed. And even if we look at the content of its decisions, we see that many of them are actually biased, going squarely against EU law. If they violate EU law, again, the Court of Justice said, we can disregard them. And that is exactly what's happening in Poland at the moment. The government is simply ignoring what the Constitutional Tribunal does and continues. It's not publishing the decisions in the official gazette. And with that, they do not acquire a legal force. So this is a way, it's not perfect, it's far from ideal, but that is one way to overcome it. And with that, I think, I hope that was enough food for thought. I thank you for your attention, and yeah, looking forward to the discussion.
Thank you so much, Dimitrios. That was very, very rich and very well structured, I would say. I would first like to give the floor to our external discussant, Yann Lorans. Yann, if you could turn on your camera and join us, this would be good. Yeah, Yann is there, you can see him. So Yann Lorans, from a research fellow at Reconstitution and a visiting researcher at Nova School of Law, who's working on democracy and this media dimension, so very well placed to offer some remarks and additional food for thought concerning Dimitrios' work. Yann, the floor is yours.
So first, thank you, Teresa, for the invitation, and apologies for everyone for being online. I'm very happy to act as discussant for Dimitrios Spieker, and I would like first to congratulate you for your book and your work all over those years, as you mentioned. So it's a very inspiring work, intellectually bold as well, and very influential in the academic debate, public debate, but also judicial debate. And it's a very noble objective and aim, that is finding avenues to prevent value backsliding in Europe, and more generally to look for opportunities to push forward EU values. But I have to confess that sometimes the work has sparked very deep internal debates, even certain dilemmas between my own vision of how I consider that value should be preserved and your attempts at extending the reach of Article 2. So while, unsurprisingly, I really share your objective, I have been wondering whether what you propose is actually what the EU needs, whether it doesn't go too far, and whether it can actually backfire and have counterproductive effects. So I would say my overarching question would be, how far should we go with Article 2? And I'm sure that's the question you've been asking yourself. But maybe I would like to shift the focus on, as you mentioned, measures or norms giving concrete expressions to EU values. So are those concrete expressions to values actually more important than the values themselves? And so I will try to give some substance to this question. I will try to share with you my own dilemmas and also share some, let's say, personal thinking on this political situation, this a bit dystopic situation that we have at the moment, a bit maybe beyond the realm of law. So let me start with my observation and questions on your proposals. So first, on the role of Article 2 within the EU constitutional architecture. And I actually particularly enjoy your idea that Article 2 serves as a methodological tool for a legal reconstruction of EU law around substantive hierarchy of the EU constitution. And you make this division in your book based on different level of concretization. So Article 2 would be the core, the constitutional core, around maybe the concept of essence of right. The second, you will have the constitution itself, and thirdly, the policies that are constitutionalized in the treaty. However, I think you can go even further in this hierarchization to also include secondary law. And you have not really mentioned that, and even in your presentation. But indeed, I would say that some legislation, because they aim at giving values concrete rules, may actually gain, I would say, certain constitutional status due to this substantively superior hierarchy. And I support this argument based on this priority rule that you actually mentioned in your book. You say once an EU legislation exhaustively harmonizes the field, initial market, fundamental rights, then reference to primary law becomes less relevant. And we could see that in internal market, but also in equality. So EU directive protecting equalities are now the main yardstick, and sometimes the charter is not even quoted. And that happens also with data protection and so on. So now that we have legislation defending certain values, and you've mentioned, the EMFA, the anti-SLAPP directive, I wonder what would be then the future of those legislation if we use this rule, this legislative priority rule, and then what would become then Article 2 and the values inside if we have legislation to actually give concrete expression to the values. And so then how would you fit those legislation within this architecture that you propose? My second point concerns the content of the values. And you seem to agree that the values are abstract, indeterminate, and that to identify them, we need this process of concretization that you mentioned properly. However, in your mind, you consider, and maybe I'm wrong, but do tell me, but that this process of concretization can be rationalized, that you can pacify the struggles to choose between different visions of the same values, and that we don't need to take ideology into consideration. And on this point, maybe I tend to disagree with you, because from my point of view, one value can mean very much different things, but at least claiming that you defend one value should not exempt you to explain what conception of the value you protect. So let's say we can all agree on the value of equality, solidarity, tolerance, but what matters for me is what equality, what solidarity, and what tolerance. Today, let's say, in France, Marine Le Pen, she claims that she's a feminist because she wants to protect women from migrant rapists. So she will use the value of equality, but what does it really mean? Or what does it hide as well? So that's for me the process of giving expression to value is not a rational one. It's a process of contestation, of dissensus, and of power struggle. It results in a legal norm at the end, but it is inextricably a political one, and at the end a question of choice. So I tend to believe that the concrete vision of what each value entails actually says more about the value itself, right? And so one of my questions would be, at the end of the day, aren't concrete rules giving substance to values more important than the values themselves? And maybe thirdly, on your proposal for more extensive use of Article 2 TEU in front of the court. And you have very well explained the different possibilities with reading Article 2 with different EU norms, or using Article 2 to identify distinct violation, or even autonomously. And so far you mentioned it properly, the court has only used Article 2 in combination with other norms, but you propose to go further and says, well, Article 2 should be used autonomously. But then I will ask you, so what is your methodology? You said, you briefly explained when and how, but I mean, from your perspective, the response would lie in the reasoning of the court, so identifying a consensual minimum standard beyond disagreement, identifying whether value has been negated, as Edith Chapeta said, but still, I think for me this solution puzzles me a bit. Doesn't this put too much pressure on the court? Or will judges be able to identify the content of the value, or identify when a value is negated or not? Isn't there a bit a form of selectivity in the values? I mean, I don't want to sound weird, but it is trendy now to protect LGBT, but it's not trendy to protect the human dignity of of migrants. Well, EU migrants would be an interesting concept. So, well, this selectivity also triggers questions for me. So, the other question could be, well, could this have a counterproductive effect? Let's say, imagine that now the value starts backsliding within the EU institutions, within the legislature, within the executive, within the courts as well. Well, it's a potential future, unlikely maybe, but then can this value argument be used against the values themselves? I mean, in the French context, I believe in the German context as well, I mean, many political actors mention values as their justification for action, and I'm wondering whether this is a bit dangerous. But still, this has triggered some dilemmas, and I think you have a very convincing argument, and if I push forwards my own arguments, then I find myself a bit blocked. And you mentioned the political deadlock. I think this is a great argument. Of course, if you wish for more legislative concretization of values, as I do, then, well, politicians need to agree. There needs to be a political will, and this might not be the case. Even the concretization argument is the one raised by the Hungarian government. So I found myself defending an argument defended by the Hungarian government. So I tried to go beyond this fallacy by association, and I said, well, maybe this argument can be interesting as long as you don't share the same objective. And then what do we have left? If there are no EU norms to protect individuals from value backsliding, what should we do? And I think there you make a solid argument. And I want to finish, if I have the time, but just 1 minute, with some personal thinking on this situation. Sometimes I see what we are all doing as putting a legal bandage on a cultural wound. But the wound is infected. Maybe the wound is infected, but it is fast spreading actually. And maybe the bandage is not the appropriate medication. So I think your work is quintessential in current times, but you might agree that it cannot be the panacea, and that other tracks of reflection should be explored. And sometimes I stop believing in the power of law. Increasingly, I believe that the crisis of values will not be solved by law, but maybe by something else. I think maybe it would need a more bottom-up approach, rooted within the collective society itself. Aurélien Barraud, a French philosopher, calls for a political, a poetic, and philosophical revolution. And I think we as lawyers have a role to play. I don't have the answer, but maybe one way to see it is, instead of being maybe, or on the side of being reactive and pragmatic, maybe we should be forward-looking and idealistic. Sometimes when I'm depressed by the news, I start imagining legal utopia. An ideal time and place, much after this period we are experiencing, where we find some sort of legal, philosophical, political, economic, and social harmony. And maybe we as lawyers, we could also do this, trying to find solution, but also trying to find a more ideal future. Well, thank you very much.
Thank you so much, Yann. I hope you can still hear us. I don't think we usually applaud discussants, but I think finishing with a call for idealism instead of pragmatism and for a poetic revolution warrants a good round of applause. You have a lot to unpack, but we'll give you a bit more, because Cecilia will also add to this before we pass on the floor to you, so that we also have time for a bit for the audience. So, and thank you so much, Yann.
Yeah, thank you.
Thank you. But I will be very short also to give time to the audience for the questions. And thank you very much for your presentation. I think it was very well structured, very clear, and I'm really happy so that for my students, I can say you had it twice and even better, some aspect that you were explaining. So I think I'm looking at my students. You can also watch the video afterwards before the exam, because everything that was said was really perfectly explained, and the difference also between value, principle, rule. I think that going back in this German constitutional theory was really good, and I'm a lawyer, but I feel that it was clear, and I didn't see like a completely desperate face on the audience. So there is something. Someone speaking? I don't know. Oh, yeah. Anyway. So thank you, and I also very much appreciated the difference of the temporality, what happens before the election, after the election. I think it's a very important question that we should raise. But hearing you, and so I will be straight to the point, because we need time to hear you again and to hear the audience, and also hearing Yann, it meets a huge question that I have in my mind now, is how and who should do something in this in front of this situation. So if I understand you well, of course there is Article 2. Article 2 should be applicable or recognized as being applicable outside the scope of EU competence. Article 2 is not a competence, okay? But so, if there is no competence but a general scope of application, concretely it means that it is the Court of Justice that has the last word. And so, can we consider, that's my main question, and it is related very much to what Yann said about legislation. Who should be the institution or institution, which level should be national or European, that has the last word on this question? It's a question of legitimacy. Can we really defend? Because I completely agree from a legal perspective. with what you are saying, actually. But then I have this question of legitimacy. Can we really defend that it is the European Court of Justice, these 27 judges in Luxembourg, whose nomination doesn't meet rule of law standards, by the way? This is recorded, but anyway, I'm not the only one saying that. I mean, I have a lot of course, admiration for the Court of Justice, but still, it is a big question. These judges should have the last word on the democratic standards at national level. So is it the institution that is legitimate to do that? Then I also very much agree with Yann, actually, but I was rowing a bit on his work in my last book on the protection of fundamental rights in the EU. And at the end of my book, after a long reflection, I was like, but the legislator should be a main player in that field, and there must be politicization. So in my book, actually, I'm calling for a politicization of EU fundamental rights law. I mean, because as Yann was saying, these values can be used and defined in very different ways, and it is a question of cultural, of political acquaintance, actually. So it's really a huge question, I think. I mean, and I don't have the answer. But if it is not a competence but a principle, then it is the Court of Justice. And should we think that there is a competence, maybe not a general competence, but we see that the EU institutions are more and more active adopting legislation in that field. Is that also legitimate? Do we consider that the EU has a competence to protect national democracies, you think? And I will finish with that big question. I'm short, but I think there will be reactions in the audience.
Great presentations beget great Q&As.
Yeah. Well, thank you. This is now, I have a very difficult task now to kind of synthesize this.
You can choose between
Yeah, I mean, let me structure it as follows. I agree with both of you that obviously court proceedings are no panacea, right? That is very clear. We all know that invoking Article 2 in front of the Court of Justice doesn't solve the underlying issue, the underlying socio-economic issues, right, in the respective societies. That's, I mean, we are not blind as lawyers, right? So we are not just putting, let's say, a legal band-aid on a cultural wound. What we're just trying is, I would rather describe us a little bit with like the disinfectant that we kind of put on it to kind of try to stop it spreading, right, to getting worse. So what we can do here is, and that is also what I tried to show a little bit with this idea of, okay, how should Article 2 work in terms of democratic regression? It is about keeping these channels open. It is about slowing down the process, right? And actually allowing for or maintaining a level playing field in the respective societies so that the majorities can switch one day. Because that is not the case anymore in Hungary. And I think that is something we need to acknowledge. So obviously this is just one of several issues that must be done, and we could also add education. Chris Gremonprets has wrote a wonderful book, a wonderful dissertation about this, how values can actually be used in education. We need rule of law mainstreaming, so in secondary legislation. I completely agree with all of that, right? But it's complementary. Definitely, it's complementary. So that then brings me to my next point. Who should have the final say, right? Is the Court of Justice then the last authority of Article 2? Well, if you look on paper, that is then the case. If we say Article 2 is a justiciable legal provision, then yes, obviously the Court of Justice is the forum of last resort, right? And they decide. However, and that also ties a little bit into Johan's question, how actually should we flesh out the values in Article 2? Well, we don't do that in a vacuum. And also the Court of Justice, the judges sitting there, they are not looking into the Platonic heaven of concepts and saying, oh, the rule of law is this. That's not how they operate. They usually draw on sources. And what are these sources? These sources are external, the European Convention of Human Rights. Second, internal, the common constitutional traditions of the member states. Internal also, EU legislation, right? We saw a big definition of the rule of law in the rule of law conditionality regulation. A definition that all EU institutions agreed upon, right? The rule of law means these principles. The Copenhagen criteria, that means the ones fleshed out in the accession process. All these things serve for the Court of Justice to kind of flesh out the values. And now let me tell you, who decides on the common constitutional traditions? Who decides on what a constitutional tradition in a respective member state actually is? That is not the Court of Justice. That is a national constitutional court, right? For instance, in Germany, if we talk about constitutional identity, that's the Bundesverfassungsgericht, right? Saying that. What it actually means and what it is. And what then kind of comes into the European mix. So we have also a dialogue there. So it's not just one institution, it's, and pardon my German, it's a Verbund, it's an Auslegungsverbund. So it's a composite of institutions, right? So that's the one point. The other point, and that also goes to Lorans' idea, and also who is the last resort, again, let me, just as an afterthought, I think that the Court of Justice should indeed consider a more, let's say, more judicially restrained when it deals with EU legislation, right? That's my opinion. So to actually achieve a good balance between a legislator and adjudicator, you need a certain restraint of the judiciary, concentrating on cases. And that then leads to a certain idea where we say, well, okay, the legislators also may be tasked to interpret the EU treaties and the Constitution, to engage in constitutional interpretation. That is the idea of a pluralistic approach, so to say, where there are many authorities in the legal system that can authoritatively interpret the Constitution. We see that, for instance, in the United States, where the president also interprets the Constitution, or sees that at least as his or her prerogative, all right? Well, with problematic results, but still, you have interpretative pluralism there. That is something that could work also in the European Union. And we see that the Court of Justice, if there is legislation, also takes back its intensity of review. So, yeah, so that is one thing. If we now think about values, ideology, could the Court of Justice maybe, what happens if this concept turns, right? We are lawyers and we always have to think of who could abuse this, right? Currently we like maybe the judges who sit in Luxembourg because they align with our values and they seem nice people. So, but what if that changes one day? What if they are not nice? And what if they actually use Article 2 to do some horrible things? Because they're very open-ended notions and they could say, well, in the balance of solidarity and equality, we opt for, I don't know, the one or the other, right? A more majoritarian vision that kind of ignores then maybe equality rights and goes for a solidaristic vision of I don't know what, right? So, let me tell you that it is very, 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 very difficult to capture the Court of Justice. It's 27 judges from 27 member states, all nominated from very, very different political backgrounds, with very different legal backgrounds as well, right? So some have served in institutions, others are academics. So what we see at the EU level, at the Court of Justice in Luxembourg, is it's not comparable to a national constitutional court. It's far more heterogeneous. To actually capture that through one political movement, to be honest, I think it's very difficult. Very, very, very difficult. I don't see that threat coming anytime soon. And as long as we have these very difficult, or this very heterogeneous setting, we can't trust that there will be debate, there will be discussion, and that every outcome we will like, but we can trust in the process still a little bit. That said, I advocate, and that was not in the presentation, that's my last word, I advocate for a restrained use of Article 2. I think it is dangerous. I think it can go too far. So I developed several strategies to actually restrain the use of Article 2. And then that can happen through many different avenues, right? You could say Article 2 can only be used as a negative standard, as an example, right? In every case, the court doesn't say Article 2 demands positively X, Y, Z, and that you must implement. No, they can just look, for instance, at the negative side, saying this act infringes Article 2 without stipulating Article 2 says X, Y, Z positively, right? In this specific case, there is a violation in the sense of a red line approach, right? You cross the red line without saying too much and leaving then the member state with its options how to remedy the issue, right? That is just one approach. But there are many, many more. Leaving margin of appreciations. We don't have that doctrine currently at the Court of Justice fully fledged out, right? That is one thing where a lot can be done. We can think of presumptions in favor of the member states. We can think of the negative red line approach, and but we can discuss that. And I would leave it here. So I'm not advocating for a fully fledged, the court should do this, and it's the only institution, and it should do it in all detail in the member states. That's not what I'm saying. We should handle it with care.
Thank you. Thank you so much for tackling these questions in such an expert fashion and also trying to navigate them. We now open the floor also to questions from the audience, both on site and online. So if you have questions, put them in the chat and we will just relay them. For those in the room, you can just stand up, introduce yourself, ask your question. We will repeat it, not because we don't hear you, because for the people online. Antoine.
Sure. Hello.
Yes.
So thank you very much for this very nice presentation. Really very clear and also very convincing. I found. I just had one question regarding the scope of this justiciability that you were mentioning in scenario 2, scenario 3. The fact that actually Article 2 could also bind member states outside the field of application of EU law. That seems far-fetched to me in the sense that I don't think you can have it both ways. So first, you need to find some roots in another, or some relay in another treaty primary law provision, which has unlimited ambit, which has limited scope. And then you use it, you have to have a density, and then you expand it to whatever situation using Article 2 for that. It seems like you want to have your cake and eat it. And to me, it defeats the effectiveness, the effective of Article 51, the Charter mainly. Because with the values, you can basically take all of the Charter and say, well, now it applies to it.
We collect a couple of questions and then let me answer if there's more from the audience. One there from Sophie. Yes.
Thank you very much. So I'm Sophie Jacquot, I'm the political scientist. And thank you very much. It was really fascinating. And I had a question asking how you take into account the fact that to activate, especially to activate Article 2, you need a political decision. At some point, at the very beginning, you have all the questions that you mentioned. Afterwards, who is legitimate for taking the decision? You need a decision to activate Article 2. And for example, we know that there have been some previous examples. 2009 in Lithuania, there was the anti-gay propaganda law, so-called anti-gay propaganda law, and nothing was done. The Commission, did not activate Article 2 or whatever they can have in their panorama there, for example. So how do you take that into account in the solution that you suggest? I would also add, but also I'm very sorry because I have a meeting in 10 minutes. I'm not sure I can stay there for the answer, so it's very shameful of me. But I also had a question that I would be really interested to discuss about concerning how then do you deal with this kind of illiberal behaviors within the institutions, of these governments within the institutions, in the parliament but also in the council. We know that, for example, Hungary is using a lot of infra-political means to obstruct decision making, for example, and yeah.
Great questions. There's more? Yes, Mirko.
Thank you for your presentation. It was really interesting. From my point of view, that's not a lawyer. I don't have a very good background in law. I still have a question. You were quite convincing in saying that the Court of Justice should have the final say because there are a lot of already tools that were established by the political entities. But my question is still like, is it the right move to move a lot of this, because this question is very political, even though it of course involves the rule of law, a lot of things are mainly in law. But we are in fact delegating a lot of discretion, political discretion, to a judicial actor that should not take this position. Or at least we should give the commission or the political entities more space to maneuver. I don't say it's, of course you're quite convincing. I'm trying to find some holes, but I think you're very convincing with your argument. But this may say, like, we're delegating too much political power. It's not power, but like responsibility to an actor that should take this responsibility. And thank you very much.
And the final one there, yes.
Yeah.
So that you can still answer.
Thank you so much. I had a question related to the use of human dignity, because we talk a lot about democracy and rule of law, for instance. But if we look at the Advocate General's opinion, there's this debate about the use of human dignity that she puts kind of forward without actually really using it later on. So I was wondering what your thoughts on maybe if human dignity has some kind of special place in this approach.
You're a better place to answer that.
I think that's. I do have a question, but you don't have to answer it directly.
Yeah, please don't be shy. I mean, I'm taking notes, so please.
I just want to put it. It's a bit like Sophie, because I have a question that I'm not sure you'll be able to answer because you have about 5-10 minutes, but about disobedience. Because you refer to Poland and you refer to the situation rather delicate of having a system where you have a constitutional court and you have a president that can somewhat jeopardize a process of return back to legality. What role then does this, what has been called restorative disobedience, would play? To what extent should we actually transfer a bit this responsibility to the ground level, even though, as Yann was saying, that there is that perhaps the utopia is going to come from bottom up, but what role then? To what extent can we rely on disobedience, and what role would the EU institutions have in legitimizing or supporting disobedience, which in itself is a problematic instrument of change?
Yeah.
That's just. I think you have quite a bit to tackle. There's
No. There are no questions, but online they didn't hear the question. So maybe before answering, you can just very quickly wrap up the question.
Okay. Yeah. Thank you so much for this first set of questions, Antoine. You asked whether whether Article 2 could be used as a Trojan horse, so to say, through the value of respect for human rights, which is in Article 2, to broaden actually the protection of EU fundamental rights into areas that the Charter in Article 51 specifically restricted, right? Article 51 says the member states are only bound by EU fundamental rights within the scope of EU law. Well, my answer to that is that, again, Article 2 needs to be interpreted very, very restrictively. That means that not the entire fundamental rights acquis comes within respect for human rights as a value, right? Only very, very narrow issues can fall under this. And I know I was very short here, right? If we look at the test, it's about the intensity, right? If we look at charter rights, it's then probably only about the essence, right? The essence of a charter right. And there is a debate, or there was a debate, whether the essence of charter rights can be actually restricted by Article 51, or whether the essence should not apply all the time, right? So I would say through Article 2, we use the essence. Obviously, that's a very murky notion, and Cecilia wrote an excellent article in the German Law Journal about that if you're interested. It's obviously, again, very difficult to define what is part of the essence. That leads me to your question. It was asked whether, or you asked whether human dignity, what happened to human dignity in this Commission v. Hungary case on LGBTIQ rights. Is human dignity special? Well, you ask a German lawyer, right? So as a German lawyer, I am saying obviously human dignity is sacred, and drawing on the Kantian tradition, it is the starting point for everything. But for any society, at least in Germany, that's at least the case, how we reconstruct it. It is the absolute focal point of our legal system. That is human dignity. As such, human dignity in Article 1 of the Charter might be one provision that is then probably protected in its entirety by Article 2. Right? There we probably have no distinction. But we see that also in the ECHR, right? In the European Convention on Human Rights, where we have certain fundamental rights that are absolute rights, right? And human dignity under the Charter, Article 1, is probably such an absolute right, I would say. But again, you're asking a German lawyer. And what happened in the opinion? Well, it's difficult to say. I mean, the opinion concentrates very much on Article 2, because that was the new issue. Human dignity cases are also not that many, but Article 2, I think, was where the focal point of that case was. So the rest was pushed a little bit aside. Now, I got several questions by you, for instance, and by you. Thank you for the political, let's say, how much should judges decide, and where do the political institutions actually come in? Well, first of all, the political institutions are the ones who trigger these cases, right? So, for instance, when we look at all these infringement procedures by the Commission, the Court of Justice is a court after all, right? It is completely constrained within infringement procedures by the opinion or by the claims brought forward by the European Commission. They define the case. The Court of Justice cannot escape it. It's called the ne ultra petita principle. You cannot go beyond what they want, right? What the Commission raises. If the Commission doesn't raise Article 2, the court cannot say that was a violation of Article 2. They can include it in their reasoning, and they do, but they are a court after all, right? So obviously this is a very limited tool, and we need the European Commission to be much more active, in my opinion, right? So that said, the Commission under the current treaty framework has an absolute discretion which cases they bring to the Court of Justice. It's not like a national prosecutorial service where you can say, well, if there is a violation, you need to bring the prosecution, you are obliged to do so. No, they have a complete discretion, absolute political discretion, and they guard that, obviously, right? I think that would be something where we should think about whether that's good or not. Also to bring the political institutions more into play, right? So, disobedience. Yes. How could EU institutions support a government that is disobedient because it wants to restore the rule of law? And here I think thank you. Here I think the latest infringement procedure by the Commission against Poland for actually claiming that the Constitutional Tribunal is no independent tribunal established by law is a perfect case in point, because here the Court of Justice ultimately said, yeah, you're right, the Constitutional Tribunal is no independent tribunal established by law, and their decisions violate primacy, several of them. So by referring to that of course increases their legitimacy due to primacy, because they have to implement it nationally, so they can ignore it, right? So that is the best justification that they could get. So I think that's essential. And the Venice Commission, obviously there are other institutions that come into the mix, but the Venice Commission, I must say, with its latest opinions, well, obviously they are also in a tight spot because they cannot say break the law, right? Mm-hmm. They cannot. The Venice Commission for you is an expert body within the Council of Europe that advises states when they are asked. It's legal experts. It's very prestigious, and they kind of draft opinions. And they said, well, we are sorry, but you need to obey the law still, right? Even in the transition. But I think here that's much better, because that has primacy. If you go to EU institutions, if you go to the Court of Justice.
Thank you. And thank you for ending not only remarkably on time, I would say, but also on a positive note of the good role of the institutions in this process, including in disobedience. It was, I think, a very, very rich discussion, certainly a really good start for our research seminar series, namely for the axis of rights and values. I would like to give a warm round of applause to our speaker, but also to our discussants. Thank you so much for engaging, and to our audience for visiting. If you're interested, go to EUmergencies.eu to look at all our events to follow.